This is legal literacy, people living with HIV's path to ending the HIV epidemic. And we believe that we will never end the HIV epidemic until HIV criminalization laws are reformed or repealed. So we'd like to introduce ourselves. I am not Kamaria Lasker. She is here. She led the amazing rally, Kelly, was getting us pumped up, or protest yesterday, and has lost her voice. So I will be stepping in. I'm Tammy Hott. I'm the co-executive director of the Sarah Project with Kamaria. And then I'm going to let Mrs. Kevin and Anna let them introduce themselves.
Hi everyone, I'm Kevin Lesh with the Sarah Project. I prefer EM pronouns, and I am the financial director at Sarah.
And my name's Anna Kasker, she, her pronouns. I'm the legal fellow at both the Sarah Project and the AIDS Law Project of Pennsylvania. I just started this summer after being a public defender in Massachusetts.
Thank you all for joining us. We're going to start off with some basic HIV Criminalization 101, what it is, how it impacts the community, and then Anna will go more in depth into a case study of Idaho's law. We picked that because it's like a paragraph rather than multiple different sections throughout codes. And we welcome questions, we welcome interactions. We want this to be interactive, especially at 9 o'clock in the morning, so please feel free to ask any questions that you may have as we go through. So what is HIV criminalization? It is a term used to describe laws that either criminalize otherwise illegal conduct or increase the penalties for illegal conduct based solely on a person's HIV status. We're all from the Sarah Project, which centers people living with HIV leadership to end HIV criminalization, mass incarceration, racism, and social injustice by supporting inclusive PLHIV networks to improve public policies, advance human rights, and promote healing justice. So how is HIV criminalized? Specific laws related to HIV status, sentence enhancements, oftentimes for sex workers. So if you're a sex worker living with HIV, your sentence is enhanced. And also sentence enhancements for other laws. If you're living with HIV, it goes from a misdemeanor to a felony. Prosecutions under existing broad statutes, so there doesn't need to be an HIV-specific law in order for somebody living with HIV to be prosecuted. The prosecutors have a wide range of laws that they can just pick from to criminalize people living with HIV. And then we want to also highlight, it's not just somebody who is charged or convicted, it's the threat of criminalization. So that is keeping many people trapped in abusive relationships because one partner will say, if you break up with me, if you leave, I'll go to the police and say you didn't disclose your status. So it's keeping people, just the threat of prosecution or criminalization is very abusive for people living with HIV. So this is the map. Do you know, does your law, I guess we should have asked before we put this up. Do you know if your state has an HIV specific law? Words, letters. This morning, how many of you are familiar if your state has one or not? You know, I'm so excited we have somebody from Alaska. We don't often have somebody from Alaska. We're like, we need to do strategic planning in Alaska.
We could use that.
And this map is from the Center for HIV Law and Policy, and it highlights how different these laws are across the nation. So let's see, the states with the green arrow in the center, such as Iowa, Missouri, Illinois, Michigan, Virginia, North Carolina, Georgia, Texas, Nevada, Colorado, how could I almost pass over Colorado? Washington and California, those are states that have either modernized or repealed their laws. So we are making progress. However, we have all the other states that, if they're in the maroon, they are states with HIV-specific criminal statutes or criminal laws. Those that also have the HIV-specific, and then has the cross with states with sentence enhancements. Like I said, a lot are for the sentence enhancements are for sex workers. And then 25 states in the orange that have prosecuted people living with HIV under non-specific general criminal laws. So like Texas was the first state, which is shocking, to actually repeal their law. However, that opens the prosecution up to every different law. So there's a gentleman doing 25 or 35 years for spitting at a correctional officer. So zero risk of harm, but they used spitting and HIV as a bodily fluid and that supposedly, or they claim to put the correctional officer at risk. And so 35 years for zero risk of transmission. So we encourage you to go to CHLP's site, and they also have a wonderful source book of what exactly your state law is. One reason why this is so important is because, we're mobile. I'm from Iowa, we're here in DC. If you need to know what the law is in the state that you're going to travel, if you have an encounter with somebody. So it's really important. And I didn't realize how important this was even for like our dandelions and our long-term survivors, who especially are more mobile. They really have to be aware of what the laws are because it impacts them as well. Consequences of HIV criminalization: increases stigma, reduces incentives for testing. So take the test, risk arrest. If you're not aware of your status, you can't be charged. So that was the number one talking point that worked in Iowa when we were talking to our legislators, going, this law is against it's not a good public health policy. And so our goal is to get people tested and in treatment and care, and this law is preventing that. The disparate impact against Black, Indigenous, people of color, transgender and gender diverse communities, the LGBTQ plus communities, sex workers, immigrant and migrant workers. The communities that are already over-surveilled and over-policed and if you're living with HIV, it's just another layer of criminalization. Collateral consequences, if you are convicted, if you are criminalized, your status is often disclosed in the media. So you've had your status disclosed, people are losing jobs, they're losing housing, losing family. And if, most of these charges are felonies, so after somebody is released, they don't qualify for housing, other social benefits that marginalize the marginalized even more. And it ignores science. These laws were not based on science, they were based on fear and hate and discrimination. So, ending the epidemic. According to the CDC, ending the HIV epidemic in the U.S. requires addressing structural barriers to HIV prevention and care. Current scientific and medical evidence should inform state laws and practices that criminalize actions taken by people living with HIV. And it's recommended that all states should consider updating or repealing outdated laws and policies. Unfortunately, you saw how diverse laws are per state. These are state laws, so they have to be changed at the state level. However, we do have Representative Barbara Lee that has introduced the Repeal Act for the last 12, 13 years. That while it doesn't change state laws, it it would require research on how many people have been prosecuted, what the impact is, and strongly encouraging states to modernize their laws. Okay, now this is beyond what I'm doing.
So, as Tammy mentioned, we're going to be using Idaho's law as a case study, and this is Idaho's HIV criminalization law. I wanted to put it all on one slide to emphasize that for the average person, when you first look at a criminal law or a statute, it's probably going to be overwhelming. It might look like gibberish, and it might be hard to understand what the law actually means. And I personally think that's by design. I think that's because your legislators at the State House have an easier job if there aren't advocates who are informed, who know their rights, who know what changes need to be made. And so I think there's oftentimes this idea that, oh, well, you have to be a lawyer to understand what the law is or to push to change it. And I think even though at first glance it might feel that way, I don't think that that's true. And part of my job as a public defender was helping my clients make informed decisions about things like whether to take a plea, whether to go to trial, if they were going to trial, whether to testify in their own defense or not. And so part of that involves breaking down legal concepts into things that the average person can understand. So what we're going to do is we're going to break down this law into a way that's hopefully a little bit more easy to understand, and that will also give you guidance if you're looking at your own state's law for kind of how to break this down and how to think about it. But I also want to encourage everyone, if you have any questions, I am going to be throwing out legal terms and trying to explain them in plain language, but if I'm not doing a clear enough job, please feel free to ask questions throughout this part of the presentation. So any questions about that before we get to the next slide? All right, so the first part of Idaho's law, and we will give you a handout in a little bit that lists the entire law, so don't feel like you have to remember all of this. But the first part of Idaho's law lists the elements of the crime. And so every time that you read a criminal law, for the most part, it will list the elements. And basically what the elements of a crime are, those are the things that the prosecutor or the state's attorney or the Commonwealth will have to prove if the case goes to trial. And the standard that they have to use is what's called beyond a reasonable doubt. And theoretically, the standard of beyond a reasonable doubt is the highest standard. It means beyond a moral certainty. And that's something that I think is very important, but sometimes that concept is aspirational. Because oftentimes in our criminal legal system, we have juries that do not reflect the communities that they're coming from. And there's also a lot of bias against someone who's charged with a crime. Even though people are supposed to be presumed innocent, only until or unless they're proven guilty beyond a reasonable doubt. Oftentimes in our society, if you get arrested, and your mugshot is in the newspaper, that's enough for a lot of people to say, well, this person must have done something wrong. And unfortunately in our legal system as well, even though you are presumed innocent, oftentimes people will have bail set, and so they could be incarcerated prior to trial, even though from a legal standpoint, they are totally innocent at that point in time. So the elements of a crime are kind of breaking down, okay, this is what the prosecution actually has to prove. And oftentimes it's a very small amount of criminal cases that actually go to trial. A much higher percentage of cases end up resolving with a plea because prosecutors can exercise a lot of coercion over someone. They can hang very high sentences over someone's head. And so oftentimes it's a reasonable decision for someone to decide to take a plea and to plead guilty, even if they might have a very good chance of beating the case at trial, just because the risk if you go to trial and lose could be extremely high. And so in terms of Idaho's law, there are basically two ways that the prosecution could try to prove this charge against someone. So the first way is they could try to prove that a person has exposed another in any manner with the intent to infect. So that's pretty broad, and we're going to get to the definition section in a minute, but exposes another in any manner with the intent to infect. So that's one way that the prosecution could try to prove their case. The other way, and I just want to warn everyone that the language in the statute can be triggering, and these are terms that we do not use in the community, but I think it's important to explain what the law says. So the second way that a prosecutor could try to prove the case is by proving that someone knows that he or she has been afflicted with AIDS, ARC, or other manifestations of HIV, that they transfer or attempt to transfer any of his or her body fluid, body tissue, or organs to another person. So these are the two different ways that a prosecutor could try to prove that someone has committed this crime. And I think the other thing that's important is to understand both what this law covers and what it doesn't cover. So the first way of exposure is very broad. Exposure could mean a lot of different things, but that section requires the intent to infect. And I think that's something that can be somewhat hard for a prosecutor to prove, because if you're trying to prove that someone has the intent to do something, that's something that is basically coming from their own mind. And sometimes people will, there might be some types of evidence that can suggest that someone had a specific intent to do something, but no one is a mind reader. So unless someone is, writing on social media that they intend to transmit HIV, which is obviously the most extreme and I'm sure very rare circumstance, that first section, even though exposure is very broad, intent to infect is pretty narrow. It's the second section that, and I'm not sure how often in Idaho people are charged with one section or the other, but I think the second section is really dangerous because all a prosecutor would have to prove is that someone knows that they've been diagnosed with HIV and that they transfer or attempt to transfer a body fluid, body tissue, or organs to another person.
Does it take into account, like, if somebody's undetectable or anything, or is it kind of one and done if,
So, that's a great question, and I like where your mind is going with that, but unfortunately, just based on looking at this, it doesn't, because exposure, doesn't encompass that. And then for the second part, all that you need is to show that someone has been diagnosed.
thank you.
Yeah. Any other questions about this?
So for this, because I know, just so you know, the workshop comment, the CCC was talking about if you're a sex worker, put in the jail, take your blood, realize you have HIV, and enhance the charge. So this says knowing that you have HIV or AIDS. What if you didn't know? Would this,
Yeah, so,
for this state anyway?
right, so that, so in terms of the second part of this law, that requires you to know your diagnosis. Theoretically, the first section doesn't require you to have any kind of knowledge about your diagnosis. And every state is different. So in Tennessee, like you mentioned, Cody, what often happens is someone is charged with prostitution. If they are arrested, taken to jail, they have medical tests done, oftentimes people are finding out for the first time in jail that they are diagnosed with HIV. And then to make matters worse, the prosecution will give them a sentencing enhancement so that instead of being charged with a misdemeanor of prostitution, suddenly they're charged with aggravated prostitution, which is a felony, and it also requires registration as a sex offender. Yes.
So, while you saying that, it makes me think that area had to have mandatory testing. So, yes, it had to be mandatory for somebody to be tested.
I'm not exactly sure, but that seems right, because I think this goes back to the idea of informed consent, right? If people are given the option to opt in or opt out of a test, I don't think we would see as many prosecutions in Tennessee for aggravated prostitution, because people would be able to say, you know what, I don't want the jail testing for HIV.
If I could, at our LGBT center, we've actually had people stop tests in the middle because our testers tell them about the laws the test is processing. And when they hear that if I don't know my status, I can't be charged, they've actually had to stop the test, destroy it, and they've walked out. And thank goodness Idaho, that when Anna gets done with this is all we need to fix in Idaho. We don't have any sentence enhancements, that this is our HIV criminalization law. Oh, and it was enacted in 1988. So unfortunately, you were decades away.
Yes, Grace?
Yeah, I just want to talk about exposure and intent. I haven't seen it in the US, but in Nairobi, where I come from, we've had two cases. One was a pastor who went and took a bank loan and infected as many women as he could, and then did an interview with the media. And then he asked for forgiveness, so he wasn't sued. People forgave him.
Wow.
He couldn't remember the number of women he took out to the club and all that. So he got away with it. And the other one was a university student in third year who said he tested HIV positive and then also infected about 100 students and lecturers and wrote the list, put it in the notice board, and then posted on social media and told people to go and look at it in the notice board. She also asked for forgiveness and got away with it. But I don't think they would get away with it here in the US.
I mean, I think under the way that most state laws are written, that probably would be applied in many states. But I think it's important, that just goes to show how important both the geographical and cultural context is for all of these cases. So the situation in Nairobi could be very different than the situation in Tennessee or Idaho or Arkansas. So thanks for sharing. Any other questions? All right, so the next section of Idaho's law is a definitions section. And most state laws have a definitions section, or they might refer to a different law that has a general set of definitions. So in terms of Idaho's law, body fluid is defined as semen, irrespective of the presence of spermatozoa, blood, saliva, vaginal secretion, breast milk, and urine. And then transfer is defined as, indeed, feel free to come in and have a seat. engaging in sexual activity by genital contact, oral genital contact, anal genital contact, or permitting the use of a hypodermic syringe, needle, or similar device without sterilization, or giving, whether or not for value, blood, semen, body tissue, or organs to a person, blood bank, hospital, or other medical care facility for purposes of transfer to another person. So a couple things that I wanted to point out about these definitions. First, for body fluid, again, it's very broad, and we know that some of these body fluids are not ways that HIV is transmitted. And again, it doesn't differentiate between whether someone has an undetectable viral load or not. So in terms of, semen, blood, breast milk, it doesn't matter whether that's actually a way that HIV could be transmitted through that body fluid. And then for things like urine, that's included in the statute, even though it's totally divorced from any, science about how HIV is transmitted. The other thing is the transfer definition, and I think this is pretty interesting. There are kind of two broad categories within the definition of transfer. So one is various types of sexual activity that could be considered a transfer. But the other gets very specific. So it's the use of a hypodermic syringe, needle, or similar device without sterilization. And then giving, whether or not for value, blood, semen, body tissue, or organs to various groups. But they don't use the term body fluid as it's defined in the first section. Because they could have said, transfer means giving away a body fluid to a blood bank, hospital, or another person. But because what they list out is different than the body fluid listed in the first definition section, by my reading of this, they don't criminalize infant feeding, breast or chest feeding in Idaho, because breast milk is defined as a body fluid in the first part of the definition, but it's not something that is criminalized through a transfer, because the only transfers that are criminalized are blood, semen, body tissue, or organs. So this is why it's really important to kind of look at each line of a law carefully, because you might just assume, okay, it's talking about body fluids, it's talking about transfer of body fluids being criminalized, so it's all kind of the same thing. And, I'm not sure if it was an oversight or intentional, but at least based on this definition, it doesn't appear that breast milk is something that's criminalized. So that's, important and maybe somewhat promising if there's a small silver lining in what's a very bad law. So any questions about the definition section? Yes?
It's not on this slide, but I think I saw it on the other slide. One of the things, even if it's not, that's really common in criminal law that you mentioned is that there's a lot of stigmatizing language, especially in HIV criminalization statutes. And so we see things like, words like infected that are incredibly stigmatizing. And you'd mentioned in the beginning how some of this language doesn't align with how we speak as a community and using person-first language. And so at some point, I would love to have that conversation around how we as advocates shape the ways that we're talking so that we're not leaning into this kind of stigmatizing framing that sometimes we see in this language.
Yeah, I really appreciate that comment, and I think that's a great conversation to have, because especially when you're dealing with the criminal legal system, it is really easy, because such stigmatizing language is being thrown around, to just be let's keep saying these words that are incredibly hurtful. So thank you for bringing that up.
And one of the things we had to do as a coalition is one of our state senators, he was trying to help, kept calling this the fluid bill. And we had to pull Senator Nye aside and say, we know you're trying to help, but that's stigmatizing, and it also, we were so afraid that other members of the legislature would then think, oh, we'll take urine and saliva out and we've modernized the law. So we had to do some education there, both around stigmatizing language and also what a bad strategy that was to move forward with modernization.
You had mentioned earlier about legalese being kind of inaccessible to the layman. So what I noticed when we find the other one, some things are broad and some things are specific. So I think my question is that sort of on purpose to trip us up and confuse us? Because when I've looked at statutes, it's been like, well, this is really broad and vague, but then this is really specific. So what are we really talking about here?
Yeah, and I think that's why if there is a definitions section, either within the statute, that can be really helpful to look at because, you know, sometimes terms are defined and sometimes they aren't, right? So there's no definition of exposure in this law. That's totally vague. But some other words are defined. So I think that's a great point that you don't necessarily know until you look at the definition section or, you know, talk to someone to find out how are these things being defined. Yes?
I was thinking about what you said about like infant feeding and how if you really read into the law, it seems like that doesn't apply in this situation, but I also wonder if there's a lot of situations where, you know, people just have kind of a broad understanding of the law, so they might enforce that anyway, just on their interpretation, and if the person that's been, you know, accused of a crime doesn't have appropriate legal counsel in that situation, they probably, you know, in situations with like CPS involvement or something like that, like I'm wondering if there are people that are still, even if technically it seems like the law would allow that, there people are being criminalized anyway.
Yeah, definitely. And I mean, I'm not sure about what's happening on the ground in Idaho around infant feeding, but I think that's where there's a disconnect sometimes between the way a law is written and the way that it's actually being enforced on the ground. And I think your comment also brings up this point, right, that laws could potentially be enforced more broadly than they should be, but also people, you know, because this law is so opaque, people might think that it goes further than it does and live in fear, you know, and that increases stigma. You know, just having a law like this on the books has a huge impact on people and their decision making and the amount of stigma that they face, even if it doesn't actually criminalize behavior that people think it might. Yes?
Yeah. To the person's question up front, sometimes laws are just written poorly, and it happens all the time when you're trying to bring multiple coalitions together, or you're trying to make deals with people. It's like, oh, I need this language in, regardless of whether that language makes sense when it's actually going to be used. And we run into that. We're from Maryland with a couple of laws. So yeah, it's not always practically or written in the way that makes sense.
Yeah, thanks for sharing that too.
Yep.
It's a really
I was just going to say, and also, you also have to think about who's writing these laws. Idaho is no different today than it was in 1988 when this was passed. The majority of our legislature are a bunch of old white farmers and ranchers that we're trying to tackle a subject like this.
Yeah, I mean, in Colorado, when we worked on our law, we used it as an opportunity to educate everybody, and so we started off with the spit does not transmit. We went in with our language matters fact sheets and talked to every sponsor who was going to be both a prime sponsor as well as somebody supporting, and told them that it was so important for them to use this opportunity not only to try and change the laws, but also to help educate the other members of their community. And so it's really, when you put it that way and say that this is so critical and talk about language and talk about why shifting language is so important, especially, we were fortunate, our health department came in and said that stigmatizing language is a barrier to people testing, and that was one of our key arguments that we made. And so it all came together, and this is why it's so important to have people who are living with HIV as a part of any coalition and leading any coalition, because for us, we know that seeing infected in anything that refers to us feels really terrible and painful. And when we instead are saying people who are living with HIV, that feels like we are seen and a part of the process. So it's about the meaningful involvement, absolutely.
Yes, thank you for sharing that, Nipa, the meaningful involvement of people living with HIV. Any other questions? All right, so the next part of Idaho's law is a section about defenses. And in Idaho, there are two types of affirmative defenses. And what an affirmative defense means is that's something that a defendant would have to prove at trial in order not to be found guilty. And so typically, if a case goes to trial, someone who's being charged with a crime doesn't have to prove anything, right? It's only up to the prosecutor to try to prove the case. And certainly, a good defense attorney could submit their own evidence. They could cross-examine witnesses. I mean, it would basically be malpractice not to do that. And so hopefully in criminal trials, that's what people are doing. But they don't have to do any of that. If a prosecutor can't prove a case, then someone will be found not guilty. However, in Idaho, there are two affirmative defenses. And basically what this means is that let's say that a prosecutor has proven one or both of the elements that we talked about in the earlier slide, then someone would be found guilty unless they can prove one of these two defenses. So the first defense would be consent, which is defined as the sexual activity took place between consenting adults after full disclosure by the accused of the risk of such activity. And then the second defense is medical advice. So the transfer of body fluid, body tissue, or organs occurred after advice from a licensed physician that the accused was non-infectious. So the issues with this, right, are that the person who is being charged with a crime would have to present evidence. And oftentimes, once someone is charged with a crime, like I said earlier, even though they're supposed to be presumed innocent, as a society, they're judged, and as soon as they're arrested, it's like, well, they must have done something. And so when it's a credibility issue between someone who's accusing someone of a crime and someone who's being charged with a crime, those two people are not on a level playing field. And so even though a judge is going to tell a jury that you need to evaluate each witness, individually and make your own credibility determination, we know that people have both explicit and implicit biases, and those are coming into play when they're making credibility determinations. And so already the odds are stacked against someone when they have to make an affirmative defense.
So you're saying you're already guilty, now you gotta prove yourself innocent.
Exactly.
Exactly.
And then the other thing, right, is that if you look at the language of what someone would have to prove, for the first offense, they have to prove full disclosure. Well, full disclosure is not defined in a statute. And so I could see a prosecutor making an argument that full disclosure of the risk of an activity, that's much broader than just disclosing that you're living with HIV. That could mean that you yourself have to do some research and go to the CDC website and print out a list of the risk of transmission and, you know, make sure that you have up-to-date medical records and you know whether you're undetectable or not. And, you know, are you signing like a 20-page contract with someone before you have, you know, a one-night stand? It could be impossible to prove consent, because what consent is defined as is way broader than what the average person thinks that consent means. And then there are other issues with the medical advice defense. So, first of all, are you really going to be able to find a licensed physician who can say that you were non-infectious? Well, how often do you see your doctor? You're not going to your doctor every day and asking, you know, this question. So it's again, very difficult, if not impossible, to prove this medical advice defense.
The other problem with the medical advice one is it says licensed physician, and nearly half of all people with HIV are treated by an NP or a PA.
That's a great point.
Like, so, sorry, go away.
Right. Yeah, and so, you know, you might think like, okay, well, the statute isn't so bad because there are defenses. But these defenses, you know, like I said, they're almost impossible to prove. On the flip side of this, you know, another way about thinking about these affirmative defenses is you could, and we'll get into this a little bit more later, you could also have a law that says the prosecutor has to prove that someone, you know, did not disclose, or they have to prove that someone did have a detectable viral load. And there are issues with those kind of proposals. I'm not saying that that's going to solve all of the issues with HIV criminalization. I think, in fact, those will bring up other issues. But you could imagine a law that places more burdens on a prosecutor in terms of what they have to prove, rather than placing the burden on a defendant to have to prove these things. The other thing is that affirmative defenses are defenses at a trial. They're not defenses that come up at a plea. So if you're offered the choice between taking a plea and going to trial, and if you go to trial, you're facing a long sentence, and if you take a plea, a prosecutor might say, well, we'll agree to a shorter sentence. You can't say at the plea stage, well, like, I disclosed my status to the other person. That doesn't matter. All that matters is whether the prosecutor can prove the elements of the offense. So any questions about affirmative defenses? I know that this is hard to understand because it basically flies in the face of everything that we're taught about the way the criminal legal system should work. So I know it can be really confusing. Grace, and then Mark.
Yeah, I thought it's just embarrassing at this time and age that in Idaho, they're still talking of saliva and urine as modes of transmission, and that is still in the system. It should not even be in the system. And then about the body fluid, when they're accusing you of infecting someone else, do they choose whether the body fluid transmission was by saliva or is it just body fluids in general? Can you tell someone infected you by saliva or by breast milk? You know that in Uganda a lot of the men still share breast milk with the mothers. We don't think of breast milk as mother-to-child transmission, but in Uganda, when a mother has a baby, most of the men try to drink that milk. They believe it's an antibiotic for STIs and other infections. But I just want to know, when you're talking of blood body fluid, are they going to separate whether you got it through blood or through saliva or they just say body fluid in code?
Yeah, so are you talking about transmission?
Yes, do they classify which body fluid to charge you with, whether it was saliva or blood or breast milk?
You know, I'm not sure about whether that's something in Idaho that they have to break it down to that level. My guess is that a prosecutor would just charge someone with this crime, and then maybe their lawyer, the defense lawyer, would say, actually, I need more details. Tell me what you're charging someone with. So you could file something that's called a bill of particulars. That's basically asking the prosecution, okay, explain, you're saying that you're charging someone with, exposure or transmission. How are you alleging that that actually occurred? So typically, at least in the early stage, they don't have to break it down at that level of detail. But in the course of a criminal case, that is something that a defense attorney might be able to ask the prosecution to explain in more detail. And then, Mark?
Well, mine wasn't more of a question, it was more of a question and statement. For taking a plea or going to court. So you got the middle of which one, if you go to court, you might get more time. If you take a plea, you still don't want to go to jail. So you still stuck with the years. So you damned if you do and damned if you don't.
Yeah, and oftentimes that decision is made even more difficult if someone has a bail set that they can't afford to pay. Then, sometimes people are even offered plea deals that could involve getting out of jail if they plead guilty, but could also involve a lifetime registration as a sex offender. And so people are forced to make really difficult decisions. And unfortunately, not every lawyer does a good job of explaining the consequences of those decisions. And so oftentimes, people may not realize all of the consequences that stem from a guilty plea until they're out of custody. And then they're like, oh wait, I have to register as a sex offender. And oh wait, that means that I can't go to my kid's school. I can't go to the park. I can't see my family member. Even if someone is told like you have to register as a sex offender, they may not understand how that's really going to impact the rest of their life. Jada and then Mark.
I was just gonna say too, and sometimes like it can be a reason for someone to face deportation as well, and that doesn't necessarily get explained to them either. So I think there are a lot of collateral consequences that maybe don't get fully explained or understood when someone is pleading.
100%.
In Colorado, when we were looking at our laws before we were able to change them, we had a prostitution, and again, language is terrible, with knowledge of HIV status that shifted it from a misdemeanor to a felony. And essentially what we discovered was that when we were talking about why it was so critical to change these laws, people went and they said, well, people are not actually being charged with these laws, so why are you so worried? What we were able to discover was that they were being used to threaten people to actually plead to a lesser crime. So people didn't have a chance in court to actually be able to defend themselves even, and ended up with this sort of escalating challenge in the legal system. And so, it's terrible when you think about how, indeed, because you don't want to be charged with a felony, you would plead to something and just accept it, even though it had nothing to do with the circumstance.
Yeah, that definitely happens all the time, and it shows another issue with the criminal legal system, which is just the lack of data collection. So it can be very hard to know how these crimes are actually getting charged, especially if the more severe crimes are being charged and then there's a plea deal to bring a charge down to something lower. So yeah, it can be very difficult to try to figure out what's actually happening. And I think that also goes back to this point that by just having these laws on the books, even if people are not getting charged, not frequently being charged, that's still the threat of criminalization does not go away, and the stigma from these laws doesn't. Yes, in the back.
And I just want to confirm my understanding. So, the HIV criminalization law in Ohio is an affirmative defense law, correct? Versus most other things, or is that like all laws there? I realize we've kind of moved past that, but.
Yeah, I haven't looked at Ohio's law in a little bit, but I do believe that it does have an affirmative defense around disclosure. I don't know exactly how that's written, but that presents the same issues, and I know of at least one person serving a 4-year sentence in Ohio because he went to trial and wasn't able to prove the affirmative defense of disclosure.
It seems helpful to note here that like oftentimes prosecutors and judges will punish people who decide to go to trial because they don't want to do their job, presumably. So you get more years because you have the audacity to like engage with the justice system.
Totally. You get punished for exercising your rights because there are so many people who get arrested and charged every year. If every single one of those people exercised their right to trial, the system would grind to a halt. It's just not designed to give every person the full amount of rights that they're entitled to. But the reason why everyone says, I'm not going to go to trial is because you're right. There can be, it's called like a trial tax or trial penalty. People get punished for exercising their rights. And they're running a huge risk because they could be found not guilty, but if they're found guilty, then they can be punished in a lot of different ways. Any other questions about affirmative defenses? Just want to flag. Thank you. So the final part of the law is the penalty. And so most criminal laws will either include a penalty or they'll say, this is a certain type of misdemeanor or felony, and then you can look at a different section of the law that sets out the penalty for those types of misdemeanor or felony offenses. So in this case, the penalty in Idaho, it's a felony offense, so more serious than a misdemeanor, and it shall be punished by imprisonment in the state prison for a period not to exceed 15 years, by a fine not in excess of $5,000, or by both imprisonment and fine. So right ahead. So as you can see, this is an incredibly harsh penalty. 15 years in prison is the maximum penalty. But one thing to note, right, is this is the penalty for a single charge. So oftentimes, if people have multiple encounters with someone else, a prosecutor could charge them for every single sexual encounter or sexual act that they've engaged in. And so then, instead of looking at 15 years, they could be looking at 150 years in prison, a life sentence, because a prosecutor has a lot of discretion. And so they could charge someone with one count of the crime, or they could charge someone with multiple counts. The only silver lining about this, right, is there's no mandatory minimum penalty. So it doesn't say that someone has to get charged with a certain period of prison time. So someone could theoretically serve a day in prison. I mean, my guess is that's not how the sentencing is working in practice, based on everything we know about how the criminal legal system operates. But again, this penalty section is very important.
What I'm going to add to that, there was a young man from my area that moved away to another area, and they prosecuted him. He was in college, but they put him in the newspapers, like you were saying. It was like a witch hunt to find everybody that he had sex with, and when they got through, they had him up to like 35 years or something like that.
Yeah, and this is, prosecutors have so much power, right? So let's say they offered you a plea deal, and maybe they had charged you with 10 counts, but they say, okay, we'll just plead guilty to 1. You know, if you go to trial, you're facing a life sentence, or you can take a guilty plea and still be facing a hefty state prison sentence, but, you know, you're actually gonna be released relatively soon. It's such a difficult position to be in. Yes?
I have a patient who one time asked me whether she could charge her mom. She was born out of MPCT of HIV, and so she's been living with HIV since birth and has really suffered a lot and still suffering, visiting hospitals, coming back, visiting hospitals, and coming back. But she gave me the story about her mom that she was reckless in terms of before she was born until the time she was born, and she witnessed the mom who, I think she was practicing home prostitution. So she would bring a man today, another one tomorrow, you know, until this child was born. She grew up anyway, and right now the mom is still alive, but also sick. She is also very sick. So she one time asked me that question, and I did not know what to say. I don't know what does science have, or what does the law have on this?
Wow, there's a lot to unpack there. That's a really, really heavy question to be asked, and you know, I don't know about the specific area in the law, but I think that speaks to something about, you know, in our society, when people experience harm, we don't offer a lot of options, and I think a lot of times people immediately go to the criminal legal system thinking that, you know, I've been harmed in some way, or I'm trying to seek justice. And as we've kind of gone over with HIV criminalization, the criminal legal system does not work. It does not work for anyone. Even people who, you know, think they've experienced harm and are seeking some kind of assistance. So, yeah, that's a really, really intense question to be asked as a and I'm sure there's a lot of trauma underlying. So I think maybe this is a good time for everyone to do like a collective breath. So that everyone can kind of breathe in with me really deeply. So we've already discussed this a lot as a large group, but we wanted to break everyone up into small groups to kind of talk about the Idaho law specifically and what some of the issues are with it, and we'll hand out some copies for you. And so, just real quick, if one person from each group, we can start over here, and if one person from each group can give a very brief synopsis of what was discussed, that would be great. And then going forward, because it's taking a little while, we're gonna all be one coalition together for the rest of the session. So the first group up front, does someone want to share?
I'll go first. So our group said there were too many fluids, too much sex, no testing definition, and the medical advice limited to a licensed physician.
I mean, I disagree about the too much sex being a problem, but aside
So
from
there are
that.
sex acts included in the statute which don't transmit HIV.
Got it, all right.
But it's more fun to say too much stuff. When you did it.
All right, up front, does someone want to share?
I think we spent a lot of time trying to figure out, make sure we had a huge understanding what the law actually meant. So we went back and forth trying to figure out what each of our interpretations of it were. And then, like for instance, we had a discussion on, like, is diarrhea going to be considered as body fluid? It's not listed here, but what if the diarrhea contains blood? Or, and so we didn't, I don't know if we really got to part of the discussion where we got to the problem, but we moved on to the law, the fact that it's so convoluted that it's difficult to really come to a consensus on what it actually means.
Definitely. And then in the back, is there a third group on this side?
Yes, we had a sort of tangential conversation also, but to me, so Maryland has a criminalization law and the penalty is 3 years, and the thing that jumped out to me was just like how much more severe like this penalty is as well.
All right, and then in the back on this side?
We totally didn't talk about it.
You didn't do the assignment.
We didn't do the assignment, but we did, I mean, but we did adjacent conversations in particular about fluids that don't transmit HIV. But we also kind of went down a little bit of a side road around stigma and assumptions around vulnerability.
The other thing I just thought about, we didn't talk about this in our group, but I just thought about is this doesn't define who can make the claim. And so it doesn't have to be the partner who makes a claim that this happened to them. So I could be an officer and arrest somebody because I see a couple and just decide I'm gonna go after them.
Yeah, that's a great point, because once a criminal prosecution has begun, oftentimes if someone, is considered a quote victim, they think it's up to them. They can ask for someone to be charged, or they can ask for the case to be dismissed, when in fact, it's the government who is conducting the prosecution, and so it's totally out of the hands of anyone who's considered a complaining witness or victim.
Right, so even if I complained because somebody didn't inform me and I complained, but then I realized, oh, that's gonna make them a sex offender, and they're gonna have to register, and this and this and this, and 15 years of jail. Never mind, I don't wanna do that.
Yeah, that's not, you don't have to do it.
So to go along with what he said about being the officer, so if I was the new girlfriend of someone that had been with somebody else that wasn't with, I could say, oh, well, okay, well, they didn't have the consent, and now I'm with them, so I want to, oh, no way.
All right, was there one group or two groups? Okay.
We also didn't do the assignment, we didn't get
Sure, I would raise a couple of things. The science does not meet current science. I mean, this is, this is fake news. So that's the most glaring thing, and that even the penalty is highly excessive. I mean, this really deters people from even getting tested. If you fear being arrested or going to prison for something longer than you murder somebody and get less time than this is ridiculous.
I know.
Hey, one of the things I would add too, it kind of runs counter to federal law with the organ donation. So there's something too.
Definitely. All right, I think I'm gonna turn it over to Kevin.
Great. Okay.
Talk.
So I'm going to first of all welcome you all as new members of the Idaho Coalition for HIV Health and Safety. We have just learned about our law, and so now we have to do the hard work that coalitions have to do as we try to change these laws. And one of the first things we need to do is learn how we do that. Now, I'm just going to give you a quick overview of the process of how a bill becomes a law. But you do need to check in your state, because not all states have conference committees, and you need to find out how your state legislature works. But the first thing starts with an idea, and then a law or a bill is written and introduced in the state by a state representative or a state senator or both, hopefully. Once one of the bodies passes a law, it normally goes to the other chamber, and if passed as is, then it goes on to the governor for signature. If the House passes a version and the Senate tacks on some amendments, then normally a bill will go to something they call a conference committee, where those differences are reconciled. Then it goes back for, again, approval, and then it goes to the governor for signature, and then you actually have a law. So this is something that I'm going to give you full disclosure on this. I would love to do exactly what Illinois did and get this damn thing off the books. But unfortunately, this is an I state that's not as progressive as Illinois. And one of the things that coalitions have to deal with, and this is one of the hard things coalitions have to deal with, is what is best for the majority of people living with HIV in your state.
Yes.
If, again, my solution would be to repeal these laws in all 50 states. But unfortunately, with the political realities in Idaho, we have chosen to modernize, so hopefully we can put prosecutors on a box and protect as many people living with HIV from these laws as possible. Great. So, how to craft legislation. The legislation has got to be state-specific again. What is best for your state? Next, it depends on your goals of repeal or modernize. And again, these are hard conversations that coalitions must have. You need to make sure you have a table where everyone that needs to be there is there. And then you always make sure that people are allowed to use their voice to make sure that, again, whatever you do puts as many groups of people living with HIV in a better place than they were before. And I would even say you keep discussing until all groups living with HIV are in a better place than they were before. And then, and this can be very challenging, this is where we are in Idaho. Finding allies to help is easy. And, you know, if CERO or PWN or any other organizations, as you start doing this in your state, we can all help you identify who you need to have at your table as allies, and also give you advice on how to get them to the table. The next thing that's hard in a state like Idaho is, you know, we are a super majority Republican state. And we are the state of Ammon Bundy, if you all ever heard of Ammon Bundy, and a bunch of other wackadoodles. And so they have made inroads in the legislature. They are, I believe I think we are one vote away from the alt-right controlling the Senate. So it is a very difficult political reality. And so as you craft legislation, you have to take all these things into consideration, because in Idaho, if we wait till we have the legislature we want, I will be long gone. I will never see this happen. So I think we're just going to move on and just do this now as a coalition meeting. So we understand the law, we understand what we have to do to get it to the Idaho House and the Senate, and hopefully through conference, and then get it to the governor's desk. So real quick, let's have a quick discussion. How would you propose changing this law? What do you think we should do to start out? What problematic areas should we attack to make this better for people living with HIV in Idaho?
I think the first thing we need to talk about is that the law that's on the book does not support the science.
I agree.
That would be a good place to start.
Yes, ma'am.
Stigmas.
One more time.
Fighting conversations about the stigmas behind the law.
That's a stigma. That's a great point. Anybody else?
I would definitely look at, obviously, you're talking about a felony. Definitely move it down to misdemeanor. Definitely look at these years, possibly bring that, or move it down to misdemeanor. The years would change. A classification, obviously changing what this body fluid is. Obviously, many of these do not, you can't transmit HIV that way, so I'm making that align with proper science. Actual transmission of HIV is necessary for prosecution. Yeah, there's a commitment.
Yeah, and that was a great setup. Thank you so much, Timothy, because as we research this as a coalition, really interestingly, this portion of 39, Title 39, was written in 88. The rest of it was written in 1922. And in the 1922 sections deal with the STIs of that day. And what's interesting, and those have a different penalty section. And if you get trapped under one of those sections, if there's transmission, it's a 6-month stint in the county jail. If there's no transmission, it's a 3-month stint in the county jail. So what we have decided, well, I'll stop there and I'll take it.
So in your state, in those 1922 sexually transmitted diseases were prosecuted.
In the 20s.
But I mean, it was written in the 20s,
Yeah.
and they're still using it. I didn't know that. It's crazy.
So let's move on to the second one. What would be our talking points? What should we say to folks in the House and the Senate when we go up there to do education? What do you think that we need to say to folks, you know, as we are sitting in the Capitol Rotunda and we start seeing senators and representatives as they're on the way to meetings and everything?
Yeah, I mean, I would start off with the public health approach, which is that, you know, absolutely, if you have these laws, it's a good reason for people not to actually get tested. And so instead, we talk about that being exactly backwards, that we want more people to be able to be tested and to be getting into care, to live long and healthy lives.
I second that.
Grace.
You equals you? Ooh, that's a big deal.
Hold on to that thought, because we're gonna get there. Go ahead.
If you couldn't appeal to them through any other humanitarian need or viewpoint, what about speaking their language when it comes to money and the bottom line, and how if you're not healthy, that could affect things, right? Like if the public health in your state isn't good, that would impact the money, right? The cost of your life, the cost of care, and things like that. That's a cost to your state, your legislator, your budget.
Yeah, that's a great point, because in a state like Idaho, leading off with human rights is not, they don't crap about that in the West. But money, they do care about. And one of the things that we also through our research found out, not only do they care about money, there is a huge overcrowding problem at our men's facility. So we're going to try to use that as a road in.
Not the biggest fan of this rating, but considering your state's legislature, maybe like, you know, we're not being tough or soft on crime, we're being smart on crime.
Thank you.
It's like.
Go ahead.
Building on what you said, speaking of the rights of every human being on this earth. We all have the right, whether you're living with HIV or not. You have the freedom to express, you have the freedom to indulge in your sexual desires. So hold people accountable in regards to keeping themselves safe, as well as the same way you're trying to make all these laws, or the way that these laws have been passed to hinder people from having those experiences who live with HIV, hold people accountable who don't have it. If you're out there and you're just sleeping with anybody, you're putting yourself at risk.
Yes.
Highlighting how this law can goes against some of the goals for ending the epidemic.
And I'm going to ask, this is a question. So if I'm the coalition leader, and today I didn't even think about it, I put on my chucks with the new rainbow badge. But Am I, as a gay man, the best person to be the face of this effort in Idaho?
No,
Absolutely not.
no, you're not.
Yeah, I was also going to say maybe consider trying to find unexpected allies. So casting a really wide net, because sometimes you'll find someone who's a little bit more conservative, but this issue hits them for some reason. And so not being afraid to having those uncomfortable conversations, and of course, kind of picking the right person to have those different conversations with.
And that's why education is so important. The first year that we went to the Hill and did education, the first person down to see us was Representative Bruce Scott. And I had no idea who he was. He was not from my part of the state. And we had a great conversation, and he disclosed to me that his brother had been living with HIV for at least 15 years. Now, I was able to leave Boise and drive home that evening, and I got home just in time for the evening news. And I saw Bruce up on my TV screen as the sponsor and arguing the first year they tried to pass the trans bathroom bill. So we have got to, even though it makes my mind want to explode, we have got to do everything in our power to have an open mind and a smile on our face, because who would have thought that the sponsor of such a hideous bill we might have a way to have an inroad to, because he said, you know what he told me? He said, I think I'd like to help you with this.
Finding what's their passion. So in Arkansas, a comrade was trying to talk to some legislators and then she did some research and realized their base was veterans. She switched her tactics and started talking about how HIV affects veterans, how the VA supposedly the biggest provider of HIV care, and all of a sudden they were wanting to listen.
I was on a call with someone from Georgia, and if anybody from Georgia is here, y'all can explain it a little bit better, but they mentioned one tact that worked for them in their modernization was highlighting some of the Trump administration's HIV policies and saying, like, it's not, this is bipartisan, like, they did it, like, why can't we, like, kind of...
We talk about EHE, and we are very thankful that President Trump, got that passed, because again, it's a way to start a conversation, because I hope what's coming through is what we're doing is we're in the relationship business. We have got to build relationships with 105 people, actually 106 people in Idaho that are in the House, the Senate, and then the 106th person would be the governor. Great. And then Kelly.
One of the ways I've heard lawmakers and staffers push back when you're talking about ending HIV criminalization is in deeply misogynistic, often anti-Black ways, the ways that the laws are actually protecting women. And so really having the point that these laws trap people in cycles of violence and being able to explain that, I think, can be powerful.
Yeah. And thank you for saying staffers, because staffers are so important. We always take high NAC art contest postcards with us, and the staffers love them. 4 of them have taken, and all of them that one of each, and built collages in their cubicles, and they are very clear to tell you, a lot of them ask me how I should vote on this. So staffers are important, and the nice thing about staffers are usually there to stay. Reps and senators come and go. Staffers are usually there for the long run. So let's now talk about what we did, what we hope to do in Idaho. So, yes. So, we'd like to put prosecutors in a box. We are one of the things we're lucky to know in Idaho is we have a rabid prosecutor. Everyone, no matter what your political persuasion is, her nickname is Mean Jean, and she is mean. So we assume that there may be other Mean Jeans in the other 43 prosecutorial districts, but thank God we know there's one, because now we can craft legislation and hopefully shut her down. So what we'd like to do when we get this into the House or the Senate is we would like to change this, that I don't want to block anyone, that intentional transmission of a sexually transmitted infection a defendant is guilty of intentional transmission of a sexually transmission infection if, so we're going to define it for the prosecutors. The defendant knows that they have a sexually transmissible infection enumerated in the first section of the code. So the prosecutor has to prove that first. Then they have to prove the defendant acts with a specific intent to transmit that infection to another person. They have to prove that second, along with the first one. Then they also have to prove the defendant engages in conduct that poses a substantial risk of transmission to that person. Fourth, they have to prove, along with the other three, the defendant actually transmits a sexually transmissible infection to that person. And fifth, the other person is unaware that the defendant has a sexually transmissible infection. So we're getting rid of the affirmative defense, and that's going on the back of the prosecutor instead of the back of the person that's been accused. Next slide. Okay. So the defendant does not act with specific intent required in the first paragraph if the defendant takes or attempts to take practical means to prevent transmission. So we're starting to slowly bring in U equals U without calling it U equals U, because we do not want the legislature to go down the path that where we set up a viral underclass by only people who are non-detectable or outside don't have to worry. Failure to take practical means to prevent transmission alone is insufficient to prove the intent required. So if you're not detectable or you've taken a medication break, which should be everyone's choice, that if they get a hold of those records, they can't say that proves you had intent to transmit. Becoming pregnant while one has a sexually transmissible infection, acquiring a sexually transmissible infection while pregnant, continuing a pregnancy while one has a sexually transmissible infection, and or declining treatment for a sexually transmissible infection during pregnancy shall not result in criminal liability under this section. That's to protect, of course, women. For the purposes of this section, the following definitions shall apply. Conduct that poses a substantial risk of transmission means an activity that has a reasonable possibility of infection transmission is proven by a competent medical or epidemiology evidence. Conduct that has been determined to pose a low risk of transmission by the Centers of Disease Control and Prevention or other epidemiological evidence does not meet the definition of conduct that poses a substantial risk of transmission. So hopefully we're going to build a clause in that as science progresses, we don't have to go back to the legislature to add things. It's there. It's going to keep pace with science. And then practical means to prevent transmission shall mean any method, device, behavior, or activity demonstrated scientifically to measurably limit, reduce, or eliminate the risk of transmission of a sexually transmissible infection, including but not limited to the use of a barrier protection or prophylactic device such as condoms or adherence to an appropriate medical treatment regimen that for sexually transmissible infection as determined by a physician. So there is U equals U, but again, without calling it U equals U, so we don't alert them to that easy path to go down to build a
Part two, right?
And then the last, I'm sorry.
It's PrEP also, I believe.
Yeah,
Right?
yeah. PrEP or even, condoms.
Yeah.
Condoms. Yeah.
Yeah.
And the last one, this section does not preclude a defendant from asserting any common law defense. I may need to have Anna help me with this. From what I understand, is this allows defendants to say, hey, you don't have any jurisdiction, or any defense that a defendant might pose, they have access to, well, with that last sentence, if I understand it correctly.
I don't have much to add, but I think the idea is we're just trying to make it so that no one is precluded from presenting any kind of defense, even though the statute is designed in such a way that hopefully it's not going to get to that.
So, any questions, any thoughts? Do we need to unpack any of this?
don't want to add nothing to it, but what I see is the layout. Everything was hidden back to back. That they can go back and question.
One of the things that I absolutely love, too. One, it clearly defines legislative intent, what the actual intent of this bill is. Two, I'm telling you, I get a bit turned on seeing definitions and legislation. Because now I'm telling you, I do this so much. Literally, like, you don't have to guess. And so it's to see it in there and you clearly define what everything means. It just, there's no guesswork. And so I think a lot of times when we look at these laws or these states, a lot of times it's a lot of guesswork. There's no guesswork in there.
Yeah, I love the wording of it.
I also think using and instead of or, you know, they have to prove each and every single line of that that law in order to find someone guilty. So it's going to be extremely difficult for a prosecutor and putting them in the box, keeping them there.
Did I, go ahead, Grace.
I don't have a suggestion, but does anybody know how you'd manage the issue of the bail plea? The bail plea, where someone pleads guilty and gets out on bail, they're still charged for an offense they did commit, and that means an admission to being a sex offender.
Unfortunately, Ohio has a sex offender registry. Right now, if you are found guilty of 39608, you're not added to the sex offender. It does not do that. So
I have a quick question. If it isn't currently, what am I trying to say? If it's not currently an issue with going on a sex offender registry, should you or should you not put them in a box for that? Like list that in there that they cannot do that?
Don't open the door.
I would not open that door.
Yeah.
I would, in fact, I just completely retyped this because one of our Dems in the Senate said, because we had it written like most bills are written with strike-throughs and then new language, he said, why are you doing their homework for them? Get rid of all that and just say Title 39 is repealed and replaced with. And so we have taken James's advice and done that.
Replace.
So, go ahead. Follow? Okay, great. So again, here's a quick overview on how a bill becomes a law. Let's go to the next slide. Okay. So real quick, non-negotiables. This is something else a coalition has to constantly be on alert for, and where we're going to draw the lines in the sand. And it's important that you know you have a legislative champion you can trust. If we say pull the bill, they pull the bill. They stop it so they don't make things worse than what they are before. So a bill can be amended or changed many times before it becomes law. So again, we have got there's so much trust here that if an amendment gets attached in either the House or the Senate and they want to ramrod it through, we have got to have a sponsor that if the people living with HIV say pull the bill gets pulled. Okay. Great. So let's just talk about this as a coalition. So we're gonna present in the next session. It's in committee. The affirmative defense provisions are removed, but now an element of the crime is that the prosecution must prove that the defendant had a detectable viral load. It is not a defense that the person used a condom, engaged in sexual activity that is unlikely to transmit, or other protective measures. What are we going to do as a coalition? Do we let that pass?
Nope.
Boo.
Kill the bill.
Okay, great. So think about how many,
Yeah, no, I was gotta go.
So think of how many people are in this room, and if we have to make a decision in 20 minutes, how are we gonna handle that as a coalition? What is something that we could do?
Could do like a start, stop, continue to just quickly get a feel for the room.
Or what we've decided to do is we have we have 4 people that the coalition has put their trust in, and if we have 10 minutes to make a decision, those 4 people will make the decision and then take that back to the coalition so that we're able to do what we need to do when we need to do it. Barb?
Are those 4 people living with HIV?
Yes.
That's a critical part that needs to be mentioned, like, that's the quiet part, say it out really loud. In Colorado, we did the same thing. We had 2 people who were empowered by the rest of the group to make that decision, and we were very, very clear that they were people living with HIV. Because when we talk about the impact of these laws, they impact us differently. They land on us differently, and so to have that not be somebody with legal skills or a lawyer, I mean, we have many people who are living with HIV who are lawyers, but to have that critically be people living with HIV is so important.
And that's how we have done it too. There's a few of us from LCCH, there's just a few of us that can make those decisions, you know, if called upon at a short notice, so.
Great, and so I think those are the powers of working in a coalition. You have to understand how this process works. And again, it's all about trust and relationships. And so as you go home and start working on this in your state, if you need to, remember what you're trying to build and that you are in the relationship phase. You have a question in the back or a comment?
Sorry.
Great. So I'm going to turn it back over to Tammy. I'm just going to take a title break.
Oh, and I'm not sure what we're doing except for the call to action, but I do have one person who joined. We do have a raffle of 3 Hynak bags, if you wanted to put your name on that to be included in the raffle at the end. So the call to action is what we always need, and I need to read them because I wasn't part of the review of the slides. Find out if your state has an HIV Crime Reform Coalition. So, thank you. We can help you with that, and we'll send you an email. That's one reason why we asked for your contact information. Sarah currently works with like 20 different coalitions around the country at various stages because each state is at its own pace. But we can let you know that and ask you the information in the follow-up email. Apply for the Sarah Project Justice Institute. It's a year-long program for people living with HIV. And we are just reviewing applications for this year, so it would be in 2025. That's an opportunity. Apply for a PWN USA Policy and Advocacy Fellowship. Because PWN is a partner organization that we love and respect, and their Policy Advocacy Fellowship, which they have opened up this year to the community. So I'm sure it's on the website on how you can join those trainings, and I've joined them, and they are incredible. They bring in experts to share their knowledge. So you can join it now without being an official policy legal, which is fantastic and a great service to the community. Join the USPL HIV caucus. We are a network of networks of people living with HIV, so PWN, SARO, the Reunion Project, Thrive SS, and many other organizations of people living with HIV. It's a great way. It's just hivcaucus.org. Thank you. Identify and engage with community stakeholders in public health, which is critical to this work, and intersectional networks who are most affected. I will say that in Iowa, our last year of outreach to the legislature when we finally got our bill modernized in 2014. In 2014, we had the League of Women Voters that HIV crime reform was one of their top 3. And that's because we had also done education for 9 years. And so we had built up friends, different lobbyists, and one of our lobbyists talked to theirs, and they're like, yeah, this is something that we should do. So there are unexpected allies out there, and you just have to build those relationships. Join the Sarah's Listserv, and we'll offer that opportunity in the follow-up email as well. And join your Ryan White Planning Council. It is one way to hold the Department of Health accountable, but to find out information. I find out information, and as a council member, it's my duty to take it back to the community, but I find out the information first, which sometimes is really good, and other times it stresses you out. But it's so important, especially for people living with HIV, to be on those planning councils to hold the state accountable. So those are some things that we recommend.
I have just a quick question about that. Can you give us some examples of things that you held the state accountable for through the planning council? I am not a fan of EAT plans, so when the state had to write our new comprehensive plan, I'm like, you are not going to call it ending the HIV epidemic. I said, because as a woman living with HIV for 30 years, it's not going to be ended until I die, and I'm not going to die anytime soon to meet your plans. So that it's Stop HIV Iowa. People First language, where the funding goes, we now have the state for the first time that is funding our Iowa network of people living with HIV to do meet and greets and a wellness summit. The state is funding the actual people living with HIV to do that and to host that. So things like that, and there's so many things. Randy, he loves me. But yeah, just holding them accountable and being there and going, that's not right. Help drafting the case management standards. And it was one time when I first, and they can be intimidating, but we have the right to be there because we are the subject matter experts. But I read what they wrote, and it was automatically, if the case manager had asked my husband that question, I would have never gotten him back to care. It was stigmatizing for a heterosexual man. So I called them, I said, you cannot put that question in there. I said, I would have never got Roger back into care. So they listened and they took that question out. So it's those things that we know that they don't think about that need our input, and so many more. You know, how the budget is spent, and things like that are vitally important to being included. Sorry, I just one more question. Was there any specific ask around working in the criminalization?
Yes, so the Iowa Department of Public Health can neither support or oppose any legislation. Randy makes me say that first. However, even at the time, Iowa was a purple state, so we had Democratic Senate, Republican House, and Governor. However, the Iowa Health and Department of Health Secretary in Iowa, she got it, and she was a Republican, and she gave Randy permission to come to educational forums that I would host to share how the law impacted their work, the Department of Health's work, in prevention efforts, in care efforts. And so that was so important. And also, you know, he couldn't send Randy, Randy Mayer is our department chair or bureau chief for the HIV, STD, and hepatitis division. And I could set up meetings with legislators, and it would just so happen I'd ask one to be there to ask for the Department of Health to join the meeting because they had a question. So then he could come to meetings with legislators, and having him there with me made a huge difference, because I don't know if we would have been able to do it without the department. I know we couldn't have done it without, if they had opposed. There's no way, it would shut us down immediately, but having them be able to provide the perspective was what made us, one step further in our process.
Thank you.
Absolutely.
Something, I don't know if you all can hear me. Okay. Really quick, and I'm like, no.
Yeah.
Okay. And we're at time, so please bear with me. But this is why it's crucial for public health stakeholders to be involved, because there's many states where we get assigned to health committees or criminal justice committees, and those legislators on those committees typically won't listen to anybody unless they speak their language. So we need more mobilization of those folks that are willing to come and testify on behalf with people living with HIV.
No, thank you.
And this slide, it was supposed to be
The virtual town hall, we've got a flyer for, so please join us online on Tuesday, September 19th. Sorry.
Sorry we weren't organized with the board for the sign-in sheets, but I remember the important thing, gifts. And that, so, Tim V. Tim V still here? Oh, it's Jay, I'm sorry. Tim Jackson? I don't have my glasses, so I'm going to blame that.
Oh, yes.
Yeah.
Should I pronounce that correctly?
Yes, you did.
I'll let you.
Bobby T.
Bobby? Thank you all so much for joining us, and CeroProject.com if you want any additional information.
Follow us on social media, Facebook.
Got a plug.
Yes.
Come on, guys.